That was not assigned, so don't worry. Okay, so thank you, Brahma, and thank you to Marua for this invitation to come and speak today. So what I want to do today is just to share about the death penalty, how it has been used for what offenses in Singapore, how many people have been sentenced to death, and we'll also look at the various laws on this, drug trafficking, murder, and firearms offenses, to see what is the law on it, how has it developed, and then I will round up, lastly, on some thoughts on some of the issues surrounding this area of the death penalty. In terms of the statistics, and we only have statistics from 1991 onwards, because before that, no official data was released. So from 1991 to 2016, a total of 466 people have been executed. These are official figures from the Prisons Department. And in terms of how it has been classified into the different types of offenses, the majority will be for drug trafficking at 71.5% of this total number. They have been executed for drugs. Second will be for murder, 26.6%. So together, if you add those two, it comes up to about 98%. Very small minority, about 1.9% for firearms offenses. So this figure also doesn't tell us about the changes over the years, and there has been. In the 1990s, there was a higher number of people who were executed. In one year, in 1994, there were 76 people executed. That was the highest number in that year. Subsequently, has been falling. In the statistics for last year, for example, only 4 people. So it has been changing as well over the years. So this kind of stats give you an overall figure, but not the individual differences. Now let me talk about the offenses, because you can see that for firearms, it's actually the minority of cases. But I'm going to tell you about the law on firearms as well. Then next, I will cover drug trafficking, and finally murder. So in terms of firearms offenses, how did this death penalty come about? Before 1973, the punishment for using a firearm was actually discretionary, meaning it could be death or life imprisonment. Discretionary meaning that the judge can choose depending on the individual circumstances of the case and perhaps the background of the offender. If we say mandatory, it means that the judge has no choice. On conviction, there's only one sentence. No matter how, maybe in terms of the facts or the personal characteristics, he comes from a broken family, he was, I don't know, desperate or whatever, those will not be considered if it's a mandatory sentence. So that's what we mean. So up to 1973, it was a discretionary death sentence, but it changed in 1973 such that it became a mandatory death sentence for anyone who uses or attempts to use any firearm, including their accomplice. So use at that time meant with the intention of causing injury. The next change came in 1993, where it was mandatory even if there was no intention to cause physical injury, if at that time the person was committing a scheduled offense. Scheduled offense would be things like robbery, unlawful assembly, and so on. So if at the time of committing any one of these scheduled offenses, an arm was used, it need not have the intention of causing physical injury. That would be mandatory death as well. So you can see that before 1973, actually it wasn't mandatory, but it became more and more serious. And of course, it also applied to the accomplices. The bigger and more important category will be drug trafficking, because as you saw from the statistics, that accounted for 71 to 72% of the total number who have been executed. And how do we come to this stage? Up until 1975, there was no death penalty for drugs. The penalty was imprisonment, fine, and caning. Imprisonment could be very serious because in the case of what was classified as a Class A drug, meaning morphine, opium, or heroin, in those situations, If the drugs were trafficked to a person under 18 years of age, it can be very serious. The imprisonment sentence can go up to 30 years, fine of 50,000, and 15 strokes of a cane. So very serious penalties, but still it wasn't death. The change came in 1975 when it became mandatory death for trafficking in heroin and morphine, because it was felt that at that time the drug situation was getting worse and there was a need to do something. So it was meant as a deterrent measure. Over the years, the use of the mandatory death penalty in drugs has been extended. So the next extension, 1989, to trafficking of opium, cannabis, cocaine as well. And then in 1998, mandatory death for trafficking in ice. So in both the firearms offenses and for drugs, the change in the law which made it mandatory death came about in modern-day Singapore in the 1970s and slowly has increased in terms of the scope of coverage of the people subject to a mandatory death penalty. In 2012, there was a change in the law such that those people who traffic in drugs in two very limited situations will not necessarily be sentenced to death, because in those two narrow situations, the judge has given a discretion to impose life imprisonment instead. And those two situations will be if the defendant is a drug courier and the public prosecutor grants a certificate that he has substantively assisted the Central Narcotics Bureau in disrupting drug trafficking activities. So basically, he has to help out in the investigations, give whatever information that is known, and if the CNB is satisfied, then the public prosecutor can give this certificate to him. With that certificate, and if he is determined as well by the court to be a drug courier, then and only then the judge doesn't impose the mandatory death sentence, even though he is a drug trafficker. But in that narrow situation, the judge can give a sentence of life imprisonment and caning. Second situation is if he's a drug courier and he's proved to have some mental abnormality. We call it in short form diminished responsibility, which affects his mental capacity and his responsibility. But generally that requires a medical diagnosis to show some link between his actions and his mental state. So in 2012, there's some relaxation on the scope of the mandatory death penalty in those two limited situations. For murder, the third category, where the death sentence is frequently used, how did the sentence come about? When the Penal Code was first enacted in Singapore in the 19th century, it was a discretionary sentence, so meaning the judge could decide whether it's imprisonment or death penalty, but the change came in 1883 when it was a mandatory death penalty for murder. So this change came not from modern-day Singapore, but a lot further back. Why did that happen? Because it was felt that at that time, England imposed the mandatory death penalty for murder. So it was felt that we should align ourselves with the English law. So murder was also punished with mandatory death. But the expectation was that there could be clemency that's given. And that should be a function of the executive. And in England, that was how the system worked out. There could be mandatory death, but there could be clemency given to this person. But in the case of Singapore, as we know, how it has turned out is that clemency has been used very, very seldom. It has been used only 6 times since independence in 1965 in Singapore. Change came about in 2012 when the Penal Code was amended such that it was mandatory only for intentional murder. Now, under the law, murder can be committed in different ways. The most serious is intentional murder, wanting to cause the death of someone. But if you do something that's highly dangerous, knowing that it's virtually certain that someone is going to die from it, that is also considered murder in Singapore. So in other situations of murder, the judge has given the discretion to impose life imprisonment. with possibility of caning. So that's the background of our laws. And my comment on this is that in terms of the current legal system, 2012 amendments brought about some relaxation on the scope of the death penalty, the mandatory death penalty in Singapore. But the changes are limited because it only affects very, very special cases of drug trafficking. So if the criteria do not apply, you are not a courier, or you do not get a certificate of assistance, or if you're not suffering from diminished responsibility, you do not get this relaxation. The judge has no discretion in that case. It's still mandatory death if you have trafficked above a certain quantity of drugs. So the conditions for getting this certificate from a public prosecutor and having this diagnosis of diminished responsibility and being a courier are very important. And to be a courier already is restricted to restricted to a very narrow class of people, because courier means you transport drugs from A to B. If you do anything more, if you pack the drugs, if you find buyers, you're totally out of that scheme. So it is a very limited scope. So the mandatory death penalty is still very much out there. For murder, relaxation, yes, in terms of it's mandatory death only for intentional murder, but the case law has shown us that if public prosecutor chooses to charge a person with intentional murder, they have also succeeded, where they can show to the court it is done with intention. And in those cases, the court will have no discretion, will impose the death penalty. In cases of non-intentional murder, then there is a discretion, right, given to the court. It's life imprisonment or death. And we have also seen in the case law that even when the person is convicted of non-intentional murder, the court is willing to sentence a person to death. We do not restrict it to what has been called in some countries the rarest of the rare. It can be imposed subject to proof that it's a blatant disregard for human life, or it's the actions outrage the feelings of the community. And that has been satisfied. So even in those cases where there's discretion, the death penalty has been imposed. So the point is that there has been changes. We seem to be moving somewhat from the mandatory death, but the death penalty is still very much out there and still willingly imposed. And where life imprisonment is imposed instead of death, I have to point out that there's still caning. So for non-intentional murder, caning can be imposed as well, and it has been. In drug trafficking, where the person is a courier and gets a certificate of cooperation, there's a mandatory minimum of 15 strokes of the cane. So even if the judge gives life imprisonment, there is still going to be caning. But if the person satisfies the diminished responsibility limit, then no caning in that situation, it's life imprisonment. Now finally, I want to round off with 3 thoughts. So in terms of the death penalty, it is something that Singapore, I think, endorses, is part of our system. So any change realistically will have to come from Parliament, but I'm just floating a few ideas for consideration. One idea is that, are we satisfied that the death penalty is very, very effective, and not just effective, but more effective than other ways of punishing the person? Because whenever people talk about abolition of death penalty, it's not suggested that we don't punish at all, right? But we're saying in comparison to other ways of punishing that person, are we satisfied that it's more effective? Because the basis of the death penalty is that it's uniquely deterrent, right? It can work. That's why we have this trust in the death penalty. But do we have proof? Are we satisfied that the death penalty is more effective than, let's say, life imprisonment or life imprisonment and caning? Secondly, one of the typical situations is that the defendant is convicted in the High Court, and then he may appeal to the Court of Appeal. At the Court of Appeal, which is going to be heard by an odd number of judges, 3 or 5 usually, if the court is not unanimous, the person can still be sentenced to death. So in this situation, I'm again asking whether it's something that we are concerned about, because if there is any dissent at this final Court of Appeal, then can we be really satisfied that there is proof beyond reasonable doubt? Are we satisfied with the legitimacy, the moral authority to sentence this person to death because there's a split in the opinion of the final tribunal? Now, what I talked about was where the defendant is convicted. What if he's acquitted? If the defendant is acquitted in the High Court, prosecutor can appeal. And at the Court of Appeal, if they agree with the prosecution's appeal, the Court of Appeal can impose the death penalty in that situation. It's something similar to the earlier point in that if we look at the totality in terms of the legal system, there has been a High Court acquittal. So at least one judge did not think that this case merited the death penalty for whatever reason, whether on the facts or on the law. So if one out of the judges did not agree, then it could be 1 out of 3, assuming the Court of Appeal was heard by 3 judges and 3 of them unanimously convicted the person of death. But ultimately, if you look at it in totality, it's still not unanimous. And there's a further point in this situation, because if the person is convicted and sentenced to death by the Court of Appeal, then there's no other chance of another tribunal confirming the sentence. Unlike the other case where he's convicted and sentenced to death by the High Court, and on appeal, another tribunal, the Court of Appeal, confirms the death sentence. But in my third situation, the third bullet point is that the person is acquitted by the High Court, on appeal by the prosecution, Court of Appeal allows the appeal and sentences him to death. But that is the first time that the person has been convicted and sentenced to death, and there's no further confirmation by another tribunal. I would like to think that in such serious cases, it should always be confirmed. So you should have one tribunal passing the sentence and the second tribunal confirming the points. So these are just some rough ideas that I put out there. I'm not sure what you think of them. I'm happy to take any questions later. So thank you.